Good morning, everybody, and welcome to our next webinar. We've got a lot to talk about in the next 20 minutes, so hopefully this is very effective and will assist you guys in making pretty legitimate business decisions moving forward. As most of you know, because a lot of you guys are actually pretty active in the lobbying efforts to release additional visas, on the 20th of March, which was last Friday, the USCIS announced that actually 10 days prior, on March 10th, the final receipt date for the statutory cap of the second half 33,000 H-2B visas was hit. What it appears to be is they actually started thinking that the cap was going to get hit as early as March 4th. And that's because we have clients who have notices that were issued on March 11th, but show receipt dates of March 4th. So they began kind of identifying whether or not they were going to hit the cap as early as the 4th. A lot of that has to do with the new 1450s and 1650s, the credit card payment forms and the bank payment forms. Once USCIS identifies that the application is worthy of processing and they contact the credit card company or the banks, they are trying to guarantee that the funds are available for the processing. And sometimes either the credit card doesn't accept the debit, or the banking company doesn't recognize USCIS as a proper vendor and rejects those charges. And as a result, the applications get returned. And so, obviously, if you go back to our webinar late last year, we identify that moving away from paper filing fee checks is really kind of a political motivation. And that's because most non-immigrants don't either have banking accounts or checking accounts, or credit cards. And as a result, USCIS is looking for an excuse to reject those applications. All of that being said, basically the statutory cap got hit on the 10th of this year, and they started receiving all of those applications via premium processing. Just note that the cap actually got hit on March 5th of 2025, but that was when we actually had the paper filing fee checks. And so that the reason why I bring up the 1450s and the 1650s is basically I am of the opinion that we actually hit the cap as early as March 4th this year, which would be relatively similar to hitting the cap the year before. Obviously, they will continue to accept applications for our clients who are utilizing our strategy of moving winter employees over to an approved spring labor certification. And that's because either those H-2B workers are currently work authorized, and we're submitting an application that evidences that they were work authorized during the first half of the fiscal cap and continue to be work authorized just because they haven't reached the 3-year physical presence limit for H-2B workers. Or more notably, for a lot of you, those of you who used our winter strategy, mobilized the men after October 1st, and sent them home sometime during the wintertime, the statutory cap still doesn't apply to you. And that's because they already have a federal fiscal year 2026 visa in their passport. They just happen to be outside of the United States. We will need to process them at a consulate, but the cap actually still doesn't apply to you. So there's a lot of you who have taken on our strategy of holiday decoration, holiday illumination, where we generally have a October 1st or October 15th start date, and then we have a January 15th or January 31st end date. Those men return to their country of origin, and then we reprocess them because they've already received a visa that counted against the federal year fiscal cap. This also doesn't apply for those of our clients who do seafood processing because of a special carve out, mostly because of the power of the senators from the state of Maryland and Virginia. And then it also doesn't deal with the Guam or the Northern Mariana Islands. We don't have any clients that fall into that category, but just in case you were interested, that's how that applies. As you guys are aware, President Trump announced just a couple of weeks ago that basically he was going to create 3 troughs of supplemental visa allocations. Just realize that that is significantly different than the past 4 years of the Biden administration. The Biden administration actually had four troughs. There was an October trough, there was an April trough, there was an April 15th trough, and then there was a Northern Triangle plus four trough, which basically never got hit. There were 20,000 visas that were set aside for the Northern Triangle that included Costa Rica and some of the countries in South America. And during the Biden administration, that 20,000 never got hit. And so during the last 4 years, we were able to use that trough to persuade our clients to go ahead and recruit out of either Costa Rica or some of the other South American clients, or some South American countries to get your visas. That is no longer applicable. What the Trump administration did after a late announcement is they converted those four troughs of the Biden administration into three. You basically had the pre-April 1st filing window, which was just 18,000 visas. Then you have the April 1st to May 1st trough, which is basically 20,000 plus visas. And then you have a May 1 as opposed to a May 15 trough, which is also 18,000 visas. So the total number of visas is about 64,000 supplemental visas. But again, it doesn't include the 20,000 that were set aside for the Northern Triangle plus four countries. So you're basically looking at a lack of 20,000 visas during the Trump administration year over year versus the Biden administration. As of February 6th, okay, so I'm taking you back 6 weeks, USCIS received enough October 1 supplemental cap applications to hit that 18,000 trough. And so basically you had a situation where from what was October 1st, but actually turned out to be January 1st until the end of March, those supplemental visas were all consumed. What's interesting to note for those of you who were beneficial or beneficiaries of the supplemental, that first trough of supplemental visas, basically there was a random selection that occurred from February 2nd through February 4th. Those of us in the business are relatively positive that there were enough applications for supplemental visas that the cap actually got hit on that first day. But by rule, they needed to identify that they were still going to continue to receive applications through February 6th, but basically there were enough applications for supplemental visas on that first day that supplemental cap got hit. The second allocation that we're talking about right now is for temporary labor certifications with a start date from April 1st through April 30th. And that includes 27,000 plus supplemental visas. Those supplemental visas are set aside for individuals who are returning to the United States after successfully enjoying H-2B status during fiscal years 2023, 2024, and 2025. Those petitions were all due on Wednesday. And so for those of you who were receiving temporary labor certifications after the statutory cap got hit, beginning essentially March 4th, our team scurried and prepared applications from Friday until Tuesday of this week so that the FedExes would all be received on Wednesday. And I can assure you that, we have unbelievable paralegals that work for us, and all of those supplemental visas with the temporary labor certification of April 1st were FedExed on Wednesday. Now, for those of you who I prepared your applications, and there's a lot of you out there, I was telling you that I believed we would be able to receive receipt notices as early as today, and if not as late as Monday, indicating that you qualified for supplemental visas. And that's because I am 99% sure that because of that 15-day period from March 4th until the announcement that the statutory cap got hit, the Department of Labor was still processing labor certifications. So I want to take you guys back to the lottery announcements and that webinar from the second week of January. For those of you who have April 1 start dates, we submit your application during a 72-hour period, April 1st or January 1st through January 3rd. We just submit applications, and that's because it's not only 90 days prior to the start date, which is April 1st, but it is also the 72-hour period where DOL will receive those applications pursuant to the settlement order and the consent decree that the Department of Labor signed as a result of our Padilla case. And so what that results in is these lottery allocations. So those of you who received Lottery A, for the most part, are receiving statutory visas or are going to be eligible for supplemental visas. Those of you who are in the B trough and the C trough, we told you that because B and C cumulatively is 30,000, because there's 15 in B, 15 in Lottery C, that 30,000 amounts to the supplemental visas that were announced during the Trump administration as the second trough, which is that 27, nearly 28,000 supplemental visas. We were relatively certain that the B and C group would be completely covered by that second trough. What has actually happened is because there was such a delay in the announcement between March 4th, which is when they think they hit the statutory cap, and March 25th, which is the filing date for the supplemental visas beginning on April 1st. That 21 days amounted to 3 weeks where DOL was processing, which meant that a lot of the Ds were not only processed in time, but also had received their labor cert. So even if you're in the B and C group and you thought that you were going to be entitled to the supplemental visas, and I warned the D groups that you guys needed to apply for May 1st visas, there's going to be a lot of D clients that we have that are going to receive the supplemental visas. And that's because of this dead period of 21 days. All of that being said, we are, for those of our clients who are E, F, and G, we told you you're going to completely miss out on the visas because DOL is not going to get to your processing in the E trough in time to file for the supplemental visas beginning April 1st. And that is the case. This week, beginning on Tuesday, we started seeing the E processing. We haven't received the F processing yet, but we fully anticipate that F processing is going to begin next week. And so if you're an E, F, or G, unfortunately, you're really going to have to wait until May 1st to see your supplemental visas. And those applications can't be filed before April 25th. So we've got another 3.5 weeks for DOL to process those applications. So I think all of the E's, all of the F's, and some of the G's are going to be completed through processing by April 25th, and we can still apply for the main visa supplemental release, but there's only 18,000 visas that are available at that time. And that's why when we get to the end of the webinar, we're going to stress kind of these alternative strategies moving forward. And a lot of that has to do with the fact that we firmly believe that the Trump administration is not using this as a one-off year, but will probably follow the same pattern for the next 3 years. So as of March 25th, USCIS received more than enough petitions to allocate the 27,000 plus supplemental visas. And what we think is going to happen is they're going to continue to process applications from what is Wednesday through next Tuesday. That is going to then conduct a random lottery for USCIS visas. Remember, guys, and this is a discussion that I've had with a bunch of our clients, there's a difference between the A, B, C, D, E, F, G lottery that the DOL conducts, and then just the supplemental visa lottery that USCIS does. There's no letter groupings for USCIS. So it is possible that, notwithstanding the fact that you win the DOL lottery, you're a lottery group A, B, or C, you lose the USCIS lottery. So there's quite a bit of randomization associated with the selection of these applications that are seeking the supplemental visas. Just be patient, guys. We've grown this little tiny practice into a pretty significant practice. We are fairly certain that we're going to have extra visas and enough visas from everybody. You guys would be your hearts would fill with joy knowing that We've got a bunch of clients who have extra visas that they're willing to give up for others, so that everybody kind of wins. We think that we're going to be in that position again this year. And so just please be patient with us as we try and allocate those extra visas. Um, like I said, the third allocation, we can't file any of these petitions earlier than April 24th, which apparently is 45 days after the second half statutory cap is reached. And so if you are in the current labor certification process, please be pretty vigilant about sending us the recruitment report, because we think that we're going to have your application prepared and teed up for an April 24th filing for that May group of supplemental visas. What does that really mean? What it means is, for those of our winter clients that were beyond D, where you've got guys that are still working for you with an April 1st or an April 15th end date, and you're looking at waiting until we can get that either E, F, or G group processed, you probably should consider applying for an extension for those guys so that they can remain in the United States while we wait for DOL to adjudicate those applications. You're not qualifying for supplemental visas, but I do want you to continue to work those guys, because if we get the extension filed, then conceivably we can file for your May 1st supplemental visas, and the extension will serve as a bridge to move your essentially your April holdovers from the winter's temporary labor certification until your May 1 supplemental visas are available. All of that being said, realize that non-immigrants present in the United States admitted for a specific period of time may request extensions as long as they're here and as long as we have a really good reason to keep them there while they continue to work. And the best reason of all is DOL is really slow at adjudicating these applications. I mean, we are at the end of March and they are barely now getting to the e-lottery group. And they've been processing these for now 3 months. And so if you guys are political actors, like I've urged you to be, what we really need to do is get DOL to start processing these applications faster. And I don't want to suggest this because it'll cost you money. But if DOL started charging for labor certs, and in exchange for those fees associated, they started hiring a bunch of labor certifying officers, that actually may be a better result than waiting for the few labor certifying officers to actually adjudicate our applications prior to that April 24th, 2026 filing date for the May 1 supplemental visas. I keep asking you guys to be patient. I'm sorry about that. You really need to be patient if you're just relying upon a spring temporary labor certification strategy. For those of you who are new to us, and there's about 80 of you that are out there listening to the webinar that are new to us this year, we stress kind of these overlapping strategies with either a winter temporary labor certification so that you can transfer your winter guys to a spring need, or we utilize that winter strategy to get first half statutory visas in each of our men's passport so that when we apply for their spring visas, they don't count against the cap. And that's really what I'm going to stress with you guys moving forward is we are in a pretty significant kind of uncertainty period just because of the tardiness of the Trump administration in announcing how they were going to approach supplemental visas. I have no guarantee that they're going to follow the same practice moving forward. The only way that I can guarantee that you're going to get your spring guys next year is if we employ a winter strategy. Like I told you guys, I'm always happy to talk to y'all on the phone, but the best way for me to do that is to send an email to your paralegal and ask me for a teleconference. My Mondays and Tuesdays are basically back to back of about 30 phone calls. So if you want to talk to me, I know I've given you my cell phone, but don't call the cell phone unless you probably make an arrangement for me to set aside time to talk to you. If you can, email is always preferable, guys, and that's because with all of you out there, we like to keep track of what we told you. And it's really hard to do that unless we've got some sort of written record of what we told you. And remember, escalation is always possible. If you're having a difficult time getting a hold of your paralegal, just email all of the paralegals at immigration@kjpartners.law, and we'll figure out if we can get back to you right away. We're going to talk about mobilization. A lot of you guys are going through mobilization now. We don't know what the consulates are going to look like. A lot of us are using either Solstice or Monarch Butterfly, and we're getting a lot of really good recommendations from both of our processors to consider moving away from Monterey and moving into either Ciudad Juarez or into Merida, which is actually in the northern Yucatan Peninsula, just because those consulates have a lot of more processors, but a lot less traffic, a lot less volume, and that might be the way to go. So with that, I really appreciate you guys taking time out of your busy day to let us talk to you about this. And we will be updating you as often as we can. Have a great weekend.